this is Matt on the Moon Family Sedan channel. I want to share with you some recent comments from attorney John Deaton as to what the greatest danger, the most, quote, real danger is to Ripple and XRP holders. And it also highlights why it's so important that there have been multiple third parties, 13 third parties actually to this point, that have filed amicus briefs in support of Ripple and XRP holders as a result. And also, so several days ago, we got the terrible ruling from the judge in the SECV library case. And there are a number of reasons that was wrong. I'm not going to do a full breakdown of that in this video. But one of the things that was really grinding my gears about that is that there was no path forward for the LBC token. There was no indication of its status in the whole thing. Well, there was a post that was shared the post was written on Reddit, but it was shared by the official library account, and it articulates in detail. It's an excellent post. I'm going to share it with you. It articulates why there actually may be a positive path forward for LBC despite the terrible ruling, because you need to, and the judge is distinguishing from, past sales of the LBC token versus future sales. So at this point, what we've gotten is a very negative, very bad ruling with LBC sales up to this point, but no indication really of what that even means for, sales on secondary markets, what it means for the sale and trading of LBC moving forward. And, it just makes you wonder, like, even if we got a horrendous outcome in the SECV Ripple case, it doesn't mean that there wouldn't be some sort of conclusion where there's a path forward for XRP. And I don't even think that we're going to get some sort of terrible ruling from Judge Torres, because there's different precedent where the Ripple case is being tried compared to where the library case is being tried. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here we go. There was a tweet from an attorney named Jesse Hines the other day, and he wrote, well, the same ruling in two different district courts is basically game over, they win. And so what's being referenced there is that the library case has been tried in the First Circuit, while the Ripple SECV Ripple case is being tried right now in the Second Circuit. And there are different legal precedents within each circuit, which is a crucial thing to understand. And here's what attorney Deaton had to say in response to that. He said, I agree with Jesse. If Judge Torres rules exactly the same as the library ruling, it would be game over in the United States until the Second Circuit overturned her, if it did, or alternatively, the Supreme Court in 4 to 5 years. Like I said, the Ripple brief was written for the Second Circuit. So let's pause to note specifically, if this doesn't go well, and if that ruling from Judge Torres, should it be bad, if it can't be overturned, this thing likely ends up in the Supreme Court. I can't imagine the Supreme Court turning down an opportunity to find something on this case. And they don't have to take every single case that comes their way, mind you. But one like this, yeah, I think it's highly probable. So let's just hope it doesn't go that far. Let's definitely hope it doesn't go that far. And then attorney Deaton says, in Crypto Law US's live stream, he said, if Crypto Law US's live stream was longer yesterday, I would have explained the real danger to Ripple is that the SEC doesn't have to prove the actual sale of an unregistered security. It only has to prove Ripple made an offering of an unregistered security. So pause to note here. That distinction is of crucial importance, and the degree to which this is crucial, I probably wasn't sufficiently appreciating, just to be honest with you. But, even if Ripple had sold nothing, if there is a perceived offering, then yeah, you're still in trouble, which is basically what's found in the library case. That's the opinion of the judge anyway. So think about that. Even if Ripple sold 0 XRP ever, the judge could find that there was still an offering being made. And so this is why it's crucial to differentiate between, sales between Ripple and whatever parties they sold to versus sales on secondary markets. That's actually crucial. And then attorney Deaton says, this is why it was so important for XRP holders to be involved as amicus. If Judge Torres agrees with the judge in library and concludes that by owning billions of XRP alone, without any other statements by Ripple, constitutes an offer, she must address secondary market sales. So pause to note this. Even the SEC and the SEC v. Ripple case never cited the large quantity of XRP held by Ripple as a reason that XRP either is a security or that Ripple did something wrong. That's not an argument. If you read the entire brief that was filed, the original brief, it never cites that the reason is the large quantity. But even so, even though that was never argued, the Judge Torres could still come back and say, okay, but the fact that you had this made it pretty clear that you have a very strong interest in this. And this is where you get into that whole thing too of common enterprise versus common interest. Does this make them the common enterprise because they have the incentive to build? Because I think that's a really poor decision if that were to be made in the SEC v. Ripple case. Common interest is not tantamount to common enterprise, period. But the judge in the SEC v. Library case didn't seem to get that. Anyway, Attorney Deaton continues. Some will say that she doesn't have to address secondary market sales, but I'm confident she will. I don't think she will agree with the library judge for the reasons I addressed in the live stream, but I seriously doubt that Judge Torres, after allowing us to participate for almost 2 years, would ignore secondary market transactions independent of Ripple. To do so would mean that she allowed us in as amicus, ruled that she desired to hear our perspective, and then ignored us. Yeah, exactly. I think that Attorney Deaton's right there. She's going to have something to say about secondary market sales, which we did not see in the library case, and that's important. Attorney Deaton then says, I seriously doubt that she ignores 75,000 XRP holders, Tapjets, Spin the Bits, IREMET, and the countries that have designated XRP a non-security. XRP holders' amicus brief, along with the other amici, give her the ammo she needs to distinguish between Ripple sales and secondary market transactions. But the library decision demonstrates why it was absolutely necessary that we make our presence be known. Exactly. So she could have a very piss poor ruling and decide that because Ripple holds so much XRP today, that alone indicates that, there's some sort of offering, which is, I know it would be absurd. But she could find that. And so that's what Attorney Deaton is saying is the biggest real danger. That's a quote, real danger in this case. Let's cross our fingers and hope that doesn't happen. Now, there was also this post shared by the official library account all up on Twitters. And they wrote here, did library really lose? Well, I mean, technically the answer is yes, but let's get into the nuance here. Because look, even as it pertains to the Ripple case, I've said, okay, even if Ripple technically loses and they have to pay fines for any number of previous sales of XRP, would they really be losing in the big scheme of things if there's a go-forward path for XRP, if it can be traded on cryptocurrency exchanges? Does Ripple really care? I mean, you could say that's a technical lose, but did they really lose? Did they actually really lose? Again, only technically. In terms of getting what they want moving forward, that's a win. And so is there a path forward here for LBC? Well, it turns out the answer may very well be yeah. I mean, there could be. We'll see what happens. I mean, there's potentially a path forward here. But the problem is, even so, it doesn't necessarily provide greater clarity for the world of crypto moving forward. It's just here specifically for library, there could be a light at the end of the tunnel. And so check this out. There's this post written by somebody who goes by the name Moon Slambos. Moon Slambos. I kind of like that. That's good. So this is not me. I'm formerly Moon Lambo. I'm now Moon Family Sedan because the markets are crap. But no, this is Moon Slambo with an S is not me. But anyway, this was on Reddit. And it caught my attention purely because it was shared by the official library account. So they seem to think and agree there's something to this, presumably anyway. But this was titled, Did Library Really Lose? Wait a minute, not so fast. While everyone is throwing in the towel for a total loss of library to the SEC this week, even John Deaton called it a total win for the SEC, the facts should be highlighted and the FUD should be eliminated. Did library lose its case to the SEC? That depends on how you look at it. And the real answer answer may just be not necessarily. Of course, the SEC can put out their press releases, having been victorious, and the judge, in fact, did find in the SEC's favor. But the actual result may be more nuanced. Even they point out at the bottom of their release that, quote, the court found that library violated the charged provisions and reserved the determination of relief for a later date, end quote. But what is a judgment without relief? Ergo, a final consequence. It's still wait and see. In order to truthfully assess whether library lost, and lost in the sense of the word that the judge declared library a security going forward, read the judgment. And remember, Jeremy Kauffman, that's the founder of Library, mind you, Jeremy Kauffman had previously told John Deaton that he didn't care if he had to admit that previous sales of LBC were structured as a security, as long as sales in the future were not deemed to be so, and LBC didn't have to be registered. The judge punted on what LBC is going for. So I'll just pause and note, this is the part that really bothered me. If you watch my video where I was doing my full breakdown of what happened in this, the judge never just, there's no go forward basis. It was a train wreck as far as I'm concerned. What a very poor judgment. And then to have no path forward and no certainty in terms of what LBC actually is or how to treat it. That's why they wrote here, the judge punted on what LBC is going forward. Yes, and then so it continues. Yes, he did declare LBC sales as sales of a security. However, the sales he ruled on were past sales, not present or future sales. Quote, Library argues in the alternative that it should not be required to register future offerings of LBC, even if its prior offerings were subject to Section 5's registration requirement. I decline to address this argument on the present record because Library has not explained why possible future offerings of LBC should be treated differently from the company's past offerings, end quote. That was directly from the judge in the Library case. And here, I'll even pull it up. It's a footnote here. This is the actual conclusion written by the judge here. So to translate this, just to be clear, the judge is saying that he's declining to determine how the LBC token is to be treated on a go-forward basis. So we'll see what Library has to say about that. And so anyway, then this post on Reddit continues. So I would argue one of the most important parts of the whole case was not even addressed, i.e. whether or not LBC is a security henceforth. But it needs to be addressed, or at least swept under the rug, as it were, but LBC freed from its shackles. What does it matter if past sales of LBC were sales of a security, as long as the fine is not prohibitive of Library moving forward with the LBC use case, and the future sales of LBC are not restricted or labeled as a security? I cannot say that it will happen for sure. However, in the Kick case, even though the SEC sought a permanent injunction, disgorgement plus interest, and a penalty, as in the Library case, the ultimate result was the following. And so you'll recall that there's the Kick Interactive who had their Ken token. Here is part of the finding in that. It says, quote, the final judgment permanently enjoins Kick from violating the registration provisions of sections 5A and 5C of the Securities Act of 1933. Kick is further required for the next 3 years to provide notice to the Commission before engaging in enumerated future issuances, offers, sales, and transfers of digital assets. Kick will also pay a $5 million penalty, end quote. Between the judgment and the ensuing status conference, or perhaps at the status conference, relief will need to be determined for the SEC in the Library case. Quote, the Kirk shall schedule a status conference to discuss the process for resolving any remaining issues, end quote. This should be when the consequence is determined. In the Kick case, it was about 3 weeks after the judgment was submitted. September 30th, 2020 was when the judgment occurred, and October 21st was when the determination of relief was published. So Kick itself realized that after their judgment from Judge Alvin Hellerstein, they were still in limbo, which is exactly where LBC Library is right now, though Mr. Kauffman does not seem to realize it, because he tweeted out, quote, sorry everyone, we lost. So again, to be clear here, as was the case right after the ruling in the Kick Interactive lawsuit from the SEC. They were in limbo. There wasn't a clear understanding of what that would mean for the Kin token itself moving forward. That's exactly where LBC is right now. Anyway, post continues. Kik put out a press release expressing as much on the day of their court ruling in favor of the SEC. Quote, "The ruling may raise more questions than it answers, since it applies only to our original token distribution, and no relief was specified in the ruling, but the SEC is seeking a permanent injunction, civil penalties, and engorgement." End quote. But a mysterious thing happened after the Kik case was concluded. Between when the ruling was entered and the time the case was fully adjudicated, surprisingly, on October 21st, 2020, it was announced subtly at the very end of the SEC press release that all Kik had to do, besides pay the fine of $5 million and promise not to engage in securities violations in the future, was to notify the SEC if and when it planned to sell or transfer any more of their Kin coin holdings for the next 3 years. Remember, Kik held an ICO. Library did not. But ultimately, the Kin coin was allowed to circulate and function within its ecosystem. It does so to this day. There was no disgorgement, and a fine of only $5 million was levied, a fraction of the $100 million raised during Kik's ICO of the Kin coin. Can it be said that the outcome will be the same here? I.e. that the Kin coin and LBC coin will enjoy the same fate? Is the SEC more concerned with thwarting new entrants to the cryptocurrency space, making the barrier to entry seemingly impossible to any company considering it? Or is it all based on pay to play? Does the SEC realize that once a blockchain is fully decentralized and the coins have been released into the wild, onto the exchanges for secondary sales, that it no longer has jurisdiction because the coin or token has then morphed, no longer meeting all of the prongs of the Howey test? And I'll pause to note, that is a really great question. And I've been talking about it on this channel for a long time. I mean, it would stand to reason, though. Because think about it, where is there a case exists where, I mean, where the token still exists? I mean, I guess Telegram was a little bit different, but it's like they could have completely squashed, a Kik Interactive and the Kin token. So is it that they didn't want to address that further to make for there to be some sort of assertion that even moving forward, even if it's sufficiently decentralized, that even that moving forward, did they find that would be a losing proposition for them? Excellent question, right? Then the post continues. In any case, the $64 million question is, why did the SEC allow the Kin coin to survive and continue to operate as was always intended by Kik? Is it because they paid their dues? They certainly didn't back down. They fought the suit tooth and nail. The SEC certainly wants to intimidate and for all of its opponents to back down. But if these opponents do not back down and do see it through, is the Kik case one that demonstrates that blockchain companies can indeed engage in innovation and without regulatory clarity be in the clear once it appears that the company lost, only to move forward after suffering the hellish onslaught from the SEC? Let's hope that Jeremy Kauffman continues the fight one way or another, and that LBC can move forward unobstructed with the library app being able to flourish in perpetuity. Great post, right? So look, there is a path forward even for LBC, but even so, where's the regulatory certainty? It still doesn't exist. So this could potentially be good for them, just like there's a path forward for the Kin token now, just like there should be and probably will be a path forward for XRP, even if there's a bad ruling. But this is not how it's supposed to work. This is why regulation by enforcement is so disgusting. Really burns my biscuits, folks. I am not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.